Now we are going to start our chapter number 5, contents of contract. In fact, we are studying contract law. We discussed in part 3, part 4, formation of contract part 1, formation of contract part 2. Now contents of the contract. Which of the following actions can a party take where a term of contract proves untrue? First one is sue for breach of contract, sue for misrepresentation, and sue for wrongful contract. In fact, it is not a misrepresentation, neither a wrongful contract. Proves untrue. Proves untrue means breach of contract, so there will be sue for breach of contract. A party can sue for misrepresentation when a term proves to be in untrue. So here, this is not the case. Which of the following statement is true regarding representations? A representation is not a term of contract. A representation does not induce the formation of a contract. Representation is a statement made after a contract was formed. In fact, representation is something said before a contract is formed that induces the formation of the contract but does not become a term of contract. So, a representation is not a term of contract. Then we have which of the following statements regarding implied terms is correct? Regarding implied terms is correct. Implied means part of it. The terms may be implied into the contract by statute. As I told you, part of it already included. Code do not interfere in any contract by implying terms. Code may imply terms into the contract in order to give the contract efficacy. Terms implied into contract by custom may not be overridden by express terms to the contrary. Express terms will override terms implied by custom. Implied term is simply the included terms in the contract by law or by statute. In relation to contract law, which of the following describes a warranty? A term vital to the contract that if breached entitles the injured party to treat the contract as discharge. A term subsidiary to maintain purpose of the contract that if breached entities the injured party to claim damages. A term that is not expressly stated by the parties. A term subsidiary to the main purpose of the contract. Then, if breached, entitles the injured party to claim damages. This is meaning by warranty. If there will be any problem with the product, we will provide you either replacement or we will rectify the problem. Basically, a warranty is a term subsidiary to main the purpose of the contract that if breached entitles the injured party to claim damages. A condition is a term vital to the contract. Condition is a term which is vital to the contract. An implied term is the term that is not expressly stated by the parties. That is implied term. Then we have which of those statements concerning the Consumer Right 2015 is correct? The Act applies to consumer contract but not to consumer notices. Number two, businesses are not businesses are not protected by Act. Number three, all terms in a consumer contract should be set out in plain, intelligible language. This is the right answer. Consumer Right Act 2015 applies to consumer notices. This is incorrect. Such as sign in car parks as well as to consumer contracts. Businesses are protected if they can prove they were acting as a consumer. Not word is incorrect. All terms made in plain, intelligible language. Then we have in relation to exclusion clauses, which of the following describes the contra proferative rule? Exclusion clauses are valid unless reasonable. Any ambiguity is exclusion clauses are interpreted against the person seeking to rely on them. Exclusion clauses must be validly incorporated into the contract. So here he says contra proferantem rule. Any ambiguity in exclusion clauses are interpreted against the person seeking rely on them. Contra Proferentorum rule states that any ambiguity in exclusion clauses to be interpreted against the person seeking to rely on them. Then he says, in relation to exclusion clauses, which of the following describes the main purpose rule? Purpose of an exclusion clause is not to prevent the main purpose of the contract. The main purpose of an exclusion clause is to help a weaker party avoid unfair contractual obligation. Main purpose of an exclusion clause is to give business efficiency to a contract. So what is the main purpose? Main purpose of an exclusion clause is not to prevent the main purpose of the contract. Then at what point in a contractual agreement is a representation made? When the offeree submits their acceptance to the offerer during pre-contract negotiation, when the offerer submits their offer to the offeree, once both parties have provided consideration under their agreement. A representation. Basically, a representation is something that induces the formation of a contract but does not become a term of a contract. They are made during pre-contract negotiation. So this is the definition of the representation and B is the right answer. How are express terms incorporated into a contract? By a decision to the courts, by statute law, by the parties themselves, by what is customary in the particular trade, incorporated into the contract, by decision of the court, by statute law, by the parties themselves. Express terms are expressly agreed by the parties. The other options are the examples of how terms are employed into the contract. Which two of the following statements regarding contractual terms are correct? Number one, principle of freedom of contract states that parties may include in their contract any terms that see fit. Number two, to be valid, a contract must be complete in terms. Number three, third party may determine an essential term of the contract. And number four, where a term is classified as condition, the only remedy to an injured party if it is breached is to claim damages. Basically, principle of freedom of contract. Here we are talking about contractual terms are correct. Principle of freedom of contract says that parties are generally free to form a contract as they wish. But to be valid, a contract must be complete in the terms. In its terms, parties may include a term that allow a third party to determine an essential term. When a condition is breached, the inquired party may claim damages or treat the contract as discharged. So here, what is the right answer? The principle freedom of contract states that parties may include in their contract term that see fit. Number two, to be valid, a contract must be complete in terms. So these are the validation related to the contract. An innominate term is one that could either be classified as a condition or a warranty. How is the classification of innominate term? Innominate term as a condition or warranty determined by the operation of statute law, by the offerer, by the courts, by the offeree, by the offerer, sorry, by the courts basically. The classification of an innominate term is determined by the courts. Next one is, which of the following statement concerning exclusion clause is correct? Exclusion clause means not included or not part of the contract are called what? Exclusion clauses. Now what is correct about them? Exclusion clauses are interpreted by the courts strictly. These must be incorporated before the contract is formed and are regulated by statute law. Exclusion clauses may exclude liability for negligence, but not for death or injury due to negligence. So here, the right answer is exclusion clauses are interpreted by the court strictly. Here, the word not is incorrect. Again, the word not is incorrect. Exclusion clauses are interpreted by the court strictly. They must be incorporated before the contract is formed and are regulated by statute law. Must be incorporated, not after. Then we have, which of the following exclusion clause is void under the Unfair Contract Term Act 1977? Void unfair contract terms. A clause that excludes the conditions that the seller has a right to sell the good, a clause that excludes liability for loss of profit due to negligence, a clause that excludes liability for breach of contract, any clause, exclusion clause in a contract of insurance. Under UCAT means Unfair Contract Terms Act 1977. A clause that excludes the condition that the seller has the right to sell the good is void. So the first one is the right answer. UCAT 1997 does not apply to the contract of insurance. Exclusion clauses does not Then if in commercial terms parties may exclude liability for loss or damages by negligence and breach of contract. Then next one is, which of the following statement concerning the Consumer Rights Act 2015 is correct? The act only applies to business to consumer contracts. Definitely it is relevant with the consumer, so it is relevant. This is the right answer. The only act only applies to terms that have been individually negotiated. No, only a contract will be applicable on individual negotiation. Act require particularly on areas terms. Contract require to equally visible as other terms. The act only applies to contract that have been verbally agreed. No, it is not the case. Last one is, which of the following concerning the unfair contract terms 1977 is correct? The act only applies to business contracts. Does not. This is the right answer. First of all, I would like to tell you that unfair, here we are going to protect the consumer. Here we are talking about two businesses. Contract does not apply to the terms that have been individually negotiated. Then he says the act applies to contract regarding a transfer of an interest in land. Here we have does not. Act does not apply. Act automatically, not automatically, voids all clauses that strict liability for loss or damage due to. Similarly, does apply. So A is the right answer.